to the airport.
Okay. All right. Let me double check on YouTube real quick. Make sure we are all good. Let me turn this mute. And let me turn it down, first of all. Okay. Okay. I think I hear us. I think I hear us. All right. We are back at it. And this time I got my second camera. So now I can give myself some side cam love. You know what I'm saying? I told you we gonna get a little fancy every time we come back, man. It's gonna be a little something different every single time. So it's just something for us to. Oh man, I might have to turn on my my noise reduction. You ain't? Did you hear that? In the background, I got my window open.
Oh, I thought it was a sound effect. I didn't know.
No,
No.
that was outside. But what's going on, y'all? Appreciate y'all for coming by and kicking it with us again. I think this is maybe I don't know, man. Is this our fourth live? I don't even remember.
This is the third, so it's the fifth. It's the third planned, so it makes it I think the fifth.
Okay, okay. Well, then we staying consistent, and that's the theme of everything that we talked about. You got to stay consistent, and you got to keep fighting. You got to keep moving. We have a nice topic to talk about today in terms of assumptions, and I got some things I know I want to share and get off my chest, and I'm sure Greg is gonna kick us that game that he normally does. You know how he does freestyling it,
Yeah,
DJ
yeah,
Split.
a little bit of something like that. Yeah, that's real.
A little something. Let me kick it off a little, something like this. But yeah, man, welcome y'all. Welcome to Premi Prego. This is an opportunity that I love to have with Greg, and we share and we collaborate with our channels. He's got his own, as I call it, spiel. I got my own spiel, my own thing, and then we just combine forces like Voltron, or Captain Planet, or Big Back Beetleborgs, whatever you used to watch back in the '90s, in the early 2000s. I was a big fan of Power Rangers. I really was. I was a Green Ranger fan and then a White Ranger fan. But we just have to combine forces, and I just want to thank everybody that's just joining in. You're about to learn a lot, and please don't forget to chime in on the discussion. I'm gonna be putting up the comments on stage, as we say. And if you got something to say, you got a question that you want to ask, feel free to do so. But don't forget to donate. We love gifts around here. So don't forget to make sure you give some pledges, because you know we all need a little something something for a little something something. All right, we ain't gonna do something strange for a little piece of change, but we need that loving.
Sometimes I think that's what I'm doing here, but yeah, we'll call it what it is and leave it where it is. Yeah.
Well, you want to before we kick off anything, you want to start it off with what's yours, and then I'll follow up.
Well, no, go and do yours, and then I'll throw mine in because the eyes are definitely watching. So me, uh, the world of Rockwell.
They always watching. They always watching. Well, as you all know, I like to put up the banner because this is not legal advice, and we just like to share our stories. And the law is the law. The law is not legal advice. The law is the law. Every state has law. Every state has rules. Every state has procedures. You have to find those yourself and learn them. And whatever route you decide to go, just know that you are held responsible. And in last week's conversation, we talked about AI, and I just shared it with Greg, 'cause I think that we are influencing others. I just shared with Greg that somebody had made a compilation video, AI video, the day after we did ours, and it had all the AI. It had a lot of the AI. No, it had every single one that we went over in the compilation video. I had even more set aside, like the motions that we read, motions set aside. We'll talk about that later. But I had some set aside, and we didn't get to them if we had enough time. But I thought it was interesting that let me know that that's a signal. I can't speculate whether the person was actually watching one of our channels, but it was just too ironic that that video popped up. But that's the main thing I wanted to share with you all. My name is Maestro Stevens. I'm one of the hosts here in this conversation, but I'm the only host when it comes to the channel Premi Prego, which is we'll say an acronym or a metaphor or a short name for premeditated pregnancy. I tell ladies, stop doing that trash, get the bag, put it down. Fathers need love too, as they say, bruh, men need love too, right? Martin, one of my favorite shows. And that's pretty much it. I try to help young men because this is a game that the more senior you are, the more that the more that you can show, the more that you can grow. But when it comes to my perspective, I like to help young men, and Greg helps people all over the board, all young, old, and that's what he does. So I'll let him share, and we'll dive into it.
So before we get in, as you can see inside the chat room, there's two ways to support what we do here, and particularly my work, and I try to make it beneficial for the people who are here. And one of them is actually a better deal. So I want everybody to listen closely. And also, I don't know if Maestro said, but make sure you like, subscribe to the channel, click the bell so that anytime we come up, you'll know we're going to do this, which is actually Sundays at 6:00 p.m. Eastern Standard Time. So right there, super chat right there in the chat. You get a shout out on air plus $1 for $1 off your next session with me. 50 gets you 50 off, 100 gets you 100 off. One extra step for super chatters. Email me at gdnapsy.com. That's gdnapsc@gmail.com. I'm sorry. With your YouTube name and the amount, because YouTube doesn't give me your email and I need somewhere to send your code. Now, the better deal, and everybody listen up, there you go, tell them, is the Cash App, which is $GDNAPSC, and I will double it. So 50 becomes 100 off, 100 becomes 200 off, and any amount double. Why? YouTube keeps 30% of every super chat. Cash App doesn't. I hand that difference right back to you. Drop your email in the Cash App note, and your code lands within 24 hours. Good for 90 days from tonight. Now, one ground rule: the big code book and big blocks, and nothing ever cuts a session below half price. Send big, book big, and get the deepest deal. In every stream, every time, neither one buys legal advice. I'm not an attorney. I'm not your attorney, and no amount of money changes that. What you're getting is a discount on coaching and education. Maestro is going to get into a little bit of what coaching and education can possibly do for you, particularly if you can maintain your cool. Now, if you need legal advice for your situation, I highly encourage you to hire a licensed attorney in your state. That's the deal, and I stand on it. Now, again, for tonight, any money that lands today gets the code built in with expiration November 21, 2026. And the email templates are sitting in your Gmail drafts ready to fill. Code open, support machine, and we're loaded and ready to go. Let's get with it, Maestro.
I got time.
And for those who are more familiar, I'm not an attorney. I'm licensed practice law. I do not practice law. What I've done is study law, tell people I want to learn how I gather the information, which is typically through my experiences. So I don't give information as advice to apply to your specific case, but it's general information regarding the law and lawful principles, which, by the way, belong to the people. So please use any information obtained for educational edification only. And the reason I say that is because I want nothing that I say to be construed to be legal advice. If you feel you need legal advice, I would highly encourage you to hire a licensed and hopefully competent attorney in your state and or jurisdiction and be legally advised. That being said, I'm going to swing the bat and knock it back over to Maestro.
Well, it's been a journey. I can definitely say that. We've had a small victory. I'll call it a small victory because it's not the relief that I seek, but as Greg says, you got to take what you can get. But as I always say, I ain't letting them off the hook. So, I have two shoulders, right? Just like everybody. Well, everybody ain't got two shoulders. Some people got two left feet. I don't know. But I got two shoulders. And the one shoulder, I have a Greg. And the other shoulder, I have the Kanye. And I remember sharing this with Greg the other day. He reminds me of the E.T., Eric Thomas, hip hop preacher who's number one speaker in the world. He reminds me of that. He's going to give it to you that way. I'm going to give it to you the yay way. Right. And then we're going to bridge that gap and meet between the two, because I think both things are necessary. You do have to keep your cool, as Greg says. You do have to keep your head on your shoulders. But there's times where you need that fire. You got to have that fire underneath you. And it's just all how you display it and utilize that fire. And that's something that I'm fired up. This is a very important for me because I'm fighting for my daughter. I'm not just fighting to avoid or evade child support. And I think that there's a lot of correlation and connection to a lot of what is happening when it comes to parenting time and the court record and how things move this way and that way. And I know Greg will give you the the jargon way of seeing it. I'm gonna just give it to you all the way real when it comes to this mess, because I'm telling y'all, we are in some hot water. I had to tell them to hold up now.
Hold up.
Tell them to hold up. You know you messing with the wrong one. You messing with the wrong one. You lucky they put Greg in my corner, because if they, man, wait, what? I would be coming at y'all so hard with so much fire, but that's where I would probably be messing a lot of things up. So I want to share. Should they say give the flowers while people are alive? And Greg definitely helped me recently narrow down a motion that I filed, a motion to set aside. And this motion to set aside, I had put a little bit too much in it. And Greg helped me trim it down. And based on that trimming, I actually got a victory. They set a motion for a trial, and it's been 9 months. I've been fighting to get a trial date set for 9 months, and they finally did it. So I cornered them, and I appreciate Greg for helping me do that. And today's topic and discussion has a lot to do with assumptions. There are a lot of assumptions that were made. There's a term called presume and presumptions, and I know oftentimes we get them mixed up and we use them interchangeably. So I'll let Greg correct the record, or correct my vernacular if I don't say things correctly. But I really want to talk about assumptions and how an assumption can become accepted, in case history. And if you let these assumptions get accepted, oftentimes the burden will fall on you. You'll have to correct these assumptions that were made. And you're like, well, where did that assumption come from? Why would you assume such a thing? It happens, y'all. It really does happen. And unfortunately, unless you are indigent or have indigency on your filing, you have to pay. It ain't free to fight these assumptions. I mean, I can't tell you how much money I've paid so far out my pocket to basically tell them, hey, what you're doing is wrong. You guys are making errors. I'm showing you in plain language and in legal language the errors you're making, and they continue to make assumptions and keep doing what they want to do. So, Greg, what are your thoughts on that so far?
Well, that goes back into how willing you are to invest in yourself. Even when people talk to me, and I've had plenty of people talk to me, and they'll get a couple of minutes or whatever, and I want to say this, and this may kind of come across. I hope it doesn't come across aloof. I recognize when people are trying to pick for information. We talked about this off air, and I guess I'm going to say it on there. I have no problem with it, somewhat. If I'm not really busy. But I don't answer my phone calls all the time. I have a lot of stuff going on. And one thing I didn't even mention that I guess Maestro would probably want me to, and some other people would too, is that my Supreme Court case got distributed. Doesn't mean we're going to get cert, but it got distributed to all 9 justices. And the amount of work that it takes to do anything, like I said, it's not a victory. I don't know what's going to happen. I'm hoping that they just do what the rules require. But there's a lot of work that goes into this. And how do I say this? You're looking at a product closer to full development in the pro se area. I'm not as good as a qualified attorney, I don't think at all. But you're looking at Greg almost 20 years down the road, not Greg, probably where a lot of you all calling me are, and not Greg who's had the unfortunate consequence of a lot of so-called gurus. I did have some gurus, but Greg overcame a lot of that. So if you're calling me, probably have a little bit more yourself in a proper alignment, and we might be able to get you at least moving in the right direction. Otherwise, you're not wasting Greg's time, because Greg can adequately defend himself. You might be wasting your time, which goes back to what you said, Maestro. You might let something go, or you might do something that may have a very catastrophic or adverse consequence down the road. So I just thought I wanted to put that out there for people.
Is there any example or that you want to share, based on that?
No. I'm pretty sure, people call me out, because one thing I think some people who have my best interest at heart say I shouldn't take everybody's phone call. I know that there are people who are where I was at one time, and I say I would always, if I could help more people overcome and avoid the obstacles that I had to overcome, then I'm here for that. But they have to take it seriously and not think that there's some easy way out, that there's some silver bullet remedy. I've never sold that to people, and nor would I ever. One, I don't know you all well enough to lie to you, and two, I don't like you well enough to lie to you. I don't even want you calling me, especially to waste my time. But I am here to try to be a benefit to people, and I should be that honest about it. I don't, if I say I care, I shouldn't say I don't care. I probably do a little bit, but not as much as people might think I should, because I've had some success along the way. But the facts are the facts of a case, and there's a reason why. And I'll give you the football analysis or analogy. There's a reason why the coaches are in the press box. Now, of course, you have someone in the field, but they see the game differently than you when you're playing it. Because when you're playing it, you're hyped differently than the coach calling the play. Now, we have natural anxieties calling plays or doing whatever else, but we see the entire field many times, and we can say, okay, maybe we should do this, or I'm seeing that they're leveraging this, but whatever it is, we make the adjustments, and we send the adjustments down to the players, or when I play, the coaches send the adjustments. When you become a coach, you understand what the coach's viewpoint was. When you're playing, you think you have it all figured out, and I think it's the same with this self-representation and some of the things that even what you and I did within our coaching session, because it's definitely legal advice, is, well, let's just try to look at it from this perspective. This is the tendency. This is what you're going to see in this down and distance when you see this guy do this. And the courts are kind of the same way, because you set the table. So I just see what's on there. So I say, okay, well, or you set the chessboard, or the chessboard is this way. Okay, what's your ultimate end game? Your end game, you want to have a successful outcome. Now, how can we get you to a successful outcome within the most narrow path? Now, you may want to bludgeon them to death. You want to kill a gnat with a sledgehammer. Things if you have a can of off or a can of whatever bug spray, just spray it and let's keep it going. And you got to smash the table, everything else up under the table, the foundation. You're just trying to kill a gnat, or even move the gnat out the way. The shoe fly don't bother me, get out of the way. Let's not tear down the house trying to get rid of a fly. So hopefully I'm here to help people do that as best as I can. If you just are determined to get an attorney, but which I just don't highly recommend. But if you're going to come to me, at least come to me with the added with the respect that you would come to any other professional with if you needed their assistance. Because if you don't need me, that's fine. I'm not hurt by it at all.
Well, I mean, if people can't get it right, it's on them. They gotta come correct, like you said, and it goes both ways. If you're gonna get a coaching session, you got to come correct. If you're gonna go to represent yourself, or you're going to create your plan, you got to come correct. You cannot allow them to have too much wiggle room, because they will take it. They will take it. I'm telling you, that's the reason why I keep going back to the motion to set aside that I had to write, because I needed perspective, and I needed a way for them not to try to wiggle themselves out of the situation, out of the scenario. Because I'm telling you, if they can, they most likely will take it, especially if your I would say what you're saying, what you're arguing about, what your position is. If they find it incoherent, that was a word that we had used last week, so definitely check that out. But if they find you incoherent, they're going to use that. And sometimes you may be thinking what you're saying makes absolute complete sense, and that could be also, that could be true 100%. But that's where knowing the law, knowing the rules, knowing procedure, and having the fortitude, having the consistency to just keep moving forward despite it. Because I wanted to give up multiple times in my situation, and having somebody like a Greg in your corner can be, for a lot of people, could be a very big support system. It could be sometimes your only support system, when it comes to you fighting your battles and fighting through your cases. But I recently just found something I thought was really interesting. I'm going to share my screen here because I was sharing this with Greg right before we got on, and I'm not sure if he's seen this. And I thought it was just super interesting in terms of the correlation between parenting time and child support. And I had made a connection between the two. So let me share my screen.
And I'm listening, so just keep going ahead. I'm just doing some work in the background. I have a couple of things I have deadlines on, but I'm definitely listening. So I'm interested in seeing this because, in Florida, I've told people, it's not my fault you don't live in Florida, where we have quite a few protections for parents with the 50-50, there's a what we call a presumption issue.
Uh-huh.
In the many states, they don't have that. So, but go ahead. I'm watching.
Okay, so let me get this on the stage here. Okay, so I was doing some homework as I typically like to do when I'm we doing our do right, and I found something. Here's a website called custodyexchange.com, and exchange is spelled with an X. There's no E, so custodyexchange.com. And this is they have a parenting tool, and they do a lot with parenting plans, but they do also do a lot of research. And this research here is up. It was updated March 20th, 2026. Just for those of y'all who are big on making sure that the research was updated. And I found this very interesting. If we look over here in Ohio, which is my state, we will see that it's 23.7%. Now I wish my mouse was showing the thing, but it's not. But you guys can see it. It's 23.7%. In Florida, it's 50-50, right? And this is basically how much time does dads get with their children per state. So this is about the average. And I found it very interesting, but not really. I'm just using that word interesting just for lack of other words I really want to use. But I found it really interesting how Ohio is 23.7%. And when I did the math, I didn't really do the math. I let ChatGPT do the math. And I told ChatGPT, how many days is 23.7% out of the year? ChatGPT came back with 86 and a half days. Now, in Ohio specifically, we have a deviation threshold that starts at 90 days. That's when 10% kicks in. And I found it very, very relatable in my theory on how much and what they do when it comes to the parenting time. And the fact that 23.7% is 86 days out of the year, and 90 days is what starts the threshold.
Now, let me ask you this question, because one thing about Florida is there was always a rule, and a lot of guys didn't know it when I started doing this. And keep in mind, I didn't know as much as I learned later when I was going through it and I had an issue involving time sharing. Once you exceed 20% of overnights, there's a provision that says you must deviate from the guideline. I know you love that word, must. But what I was learning is people weren't aware of it. And they were inversing, or it was in the way they approached it was inversed. They did the child support without doing the time sharing nor doing any kind of fact finding to make the determination as to what was entitled or what have you. And these are the things that I learned how to build on later on. But at the time, I already had child support orders in place. And as I began to learn how to better scrutinize and become efficient with presentation in the courtroom, that's when I was able to get a little further. So I know you're saying what the average is that they get. Now, I don't know how they make the determination as to how they get it. Are they saying this is what just happens when they combine marriage cases with regular cases? Because the marriage case, this would be a part of the marital settlement agreement typically. And for the case of guys who don't know, they just say, come in, hey, you need to pay our child support. And they don't even discuss it. In fact, in Florida, if you look up 12.040, the Florida Family Law Rules of Procedure, when the attorney makes a representation that he's doing that, he's supposed to tell you that he doesn't represent the recipient of the services. He only represents the agency. And the agency has no ability to even address an issue of custody and or time sharing. So these are things that guys can keep in mind as you're going through your situations. And again, the reason I have no problem putting it out is because although I do coach to some degree, or I'm willing to provide coaching, I just don't care. I don't really have that kind of agenda. I only have an agenda if somebody comes in and asks me for my help. Other than that, this is actually my show is giving you all another opportunity to do something I was doing for a while and don't do anymore. I do have it in my membership. I wasn't going to even talk about child support anymore. Most people don't realize child support is not Greg's issue.
What happened recently too with that? There's something for those who don't know. 27 years.
Oh, you mean the void ab initio ruling?
Mm.
And also, I have another situation, and I'm not going to give the person any air, but thankfully to the Child Support Basics group, shout out to the Child Support Basics group, we got together and started doing this for about a year and some change, just going over some of the basics of child support, hence in the name. And we also did some barbershop talk and some other programs that you can find. And the membership is actually pretty reasonable when you think about how much they can get. You can get hundreds of hours of us actually going over questions that are posed, and they get to see me, how I use the resources that you've seen, right? That they'll see the Westlaw, they'll see me pull up. I didn't have open case at the time, but I have several legitimate legal research tools that I think fully Maestro is shouting him out. I even told him what you said. My dad, who who was able to afford the cost of a lot of this as I was going through it. And I'm pretty sure, like any parent, they're like, come on, son, do we really have to do it this way? Why don't we just pay? And I just was like, the issue wasn't not paying. The issue was my principle was based upon what did the law state. Not, I don't get into, because morality is out the question with the fact of them being here. Okay, so I don't talk about morality. So I'm not that guy. But I had a lot of support, and I had support from my kid's mom. As we're getting ready, that one's going to be a pretty good show, right? When she comes on, that when they realize that this doesn't shake out to be what you think it is, and there's another aspect that we'll discuss in another show is everybody's dogging Anthony Edwards, and my thing is that he's not this, he's not involved. How much more involved was he other than the act that created the child? And that may sound harsh to people, but that's probably something where I'm going to discuss on my podcast, which is, by the way, a shameless plug. Is going to start this Tuesday night. I don't know what my first topic is going to be, but check out my podcast. Be looking on this channel. You'll see the commercial for the Greg Dogs DJ Squid podcast 2 nights a week, starting on Tuesday. But I'll delve into topics that people are used to hearing my show from DJ Squid. So you might want to bring on your big boy and big girl pants, because Squid might get loose and say some things that might shock some people. But back to the original point is I had a lot of support that got me there. And not just there, my show, what about the perjury case? Remember, I did give back 5 years. I was looking at in prison for when a judge and a cop falsely accused me of perjury with no basis whatsoever. That's the case that's actually before the United States Supreme Court. You can go to my website at gdnapsc.com. I give a chronology of what I have going on. I've had auto negligence cases that I've dealt with. I also have a ongoing auto negligence case now, and also I have a case involving that's been recently filed where I'm suing for fraud by inducement. And within the child support case, I am bringing an action against the state for negligent enforcement. So there's a lot going on. And hey, let me say this also: I'd rather not be going through this shit. Okay. But I'm glad that I do have the ability somewhat to defend myself and to make legitimate arguments. So it's not about the money; it's more, like I say, about principle.
Yeah, I agree with you there. But I can tell you right now, I'm gonna get my money. I can tell you right now, everything they done did, I'm going after it. You can't restore time that has been lost. I can never get back time from my daughter.
And that's every guy out there. You can't get back time, and that's the unfortunate part, particularly for guys who care. Now, I'll say, I probably didn't care, but the reality is, there's a lot of guys who care and care quite a bit. I think the issue is less good fathers than there are. Depending what the circumstances will probably dictate what comes from it. I think that's just an honest assessment, because I've seen so many kind of cases. I've seen guys who didn't want nothing to do with it. I've seen one night stands. I've seen lying mamas, lying and get pregnant, the primo pregnant. Your thing, prego, was it prego, whatever?
Yeah.
I've seen, a myriad of situations, and I've seen many a guy who, if you go to my page, who managed to get time sharing after I explained to him, hey, listen, just look for time sharing. It's not easy, but it's not overly difficult. If I can guide you toward time sharing, you've seen what guys who are straight street jokers, they got their kids, right? And
Yep.
you've had, the guys like Maestro who are more coffee sip or tea sippers and more clean cut. But I've had some dudes that some people would be surprised or would want to be that involved when you think about the narrative, right, Maestro?
Yeah.
Because but what did I tell you when I've seen at any school, and I'll challenge anybody out there, and actually studies have shown this. Go look at how many men actually drop their kids off at school and pick them up, especially black men.
Mm-hmm.
So when you really look at it, you're like, how did this narrative get this way? Well, that's the narrative that Maestro has an issue with, where they feed this notion that this is the way to create the courtroom burden that you're talking about in this right here. Is created because there's a narrative out there that just doesn't get challenged enough, nor challenged enough adequately.
So let's merge into that, because I want to know, and I have my thoughts and why these errors happen, like why the creating the error is so cheap, but correcting it is so expensive.
Let me say this. Somewhere in your case, and I'm speaking to the general population who's listening, somewhere in your case, there's a fact that nobody ever proved. And I'm living proof of that, right? No witness swore to it. You follow me?
Mm-hmm.
No document established it. But it's sitting in your file like it owns that the place, and the court treats it like furniture, like it's always been there.
Mm-hmm.
And here's the part that should make you sit up. You are expected to disprove it. Now,
Mm-hmm.
as Maestro and myself are going to show you how it happens and how this assumption sneaks into your case, grows up, and becomes your burden, and how you drag it back into the light and make somebody prove it or lose it, which is where you are right now, that they adequately did what they're supposed to do. So, again, I'm not here to offer legal advice. I'm a consultant and a coach, and I have, fortunately or unfortunately, I'll let Maestro make that determination, a heck of a lot of experience with this foolishness on all ends. So hopefully that gave everybody a good enough briefing to what we're going to talk about.
Well, I've noticed a pattern that, and this was something I heard somebody else talk about when it comes to, a lot of the litigation consists of a lot of paperwork, calling paperwork pushing. And this is something that, I've become more numb to more recently, but in the beginning, it was overwhelming because I have not gotten a notice in the mail or an entry that I believe gave me the relief that I was seeking. Or I can even say it like this: I haven't gotten anything in the mail besides just recently, and it's not the relief that I was seeking, but I did get a trial date. I'm glad for that procedural victory, quote unquote. But to be seeing these notices come in the mail, because when you're fighting, you're going to get noticed, or you're supposed to get noticed, right? And you're going to get mailed stuff. Now, you're lucky, and I'm calling this luck because every state is different, where you're able to get e-file or get e-noticed. In my situation, I can e-file, but they do not e-notice me, which means that I
Really?
have to be at the address. Yes, I have
Hold
to be
on.
at the current address.
Now, I'm not giving this advice, but if it were me, I would see if I had to assign a designated email address for service, because that's what I have to do. So when I assign myself a designated email address for service, then they can serve me by email. Now, even though I'm a pro se litigant, there are certain requirements that they may have to also still mail it to me. I don't know what the rule is now. I haven't checked it. There was once a time that you still had to mail it to a pro se litigant, but I do have a designated email address for service. And if you go to my Child Support Basics groups, I believe that's episode 3. We do an entire detail of setting up your online account, like I did mine, how to serve, how to get the portal. And I actually had to do that also. I had to get permission from the federal court when I filed my federal lawsuit to be allowed to file federally, to have electronic service and filing. I had to do it with the 11th Circuit Court of Appeals, which is the federal court of appeals for the federal circuit. And then also, well, the United States Supreme Court, as we know, I had to send them big boxes, right, Maestro?
I remember.
My printer is about to die because I didn't know until the last minute. Remember that I needed to have that many copies of everything. You're talking about what, 200 and some odd pages was it per 14 of those things I had to print out and send away to them.
Mm-hmm.
And this is something I've learned how to do along the way. But everything at the state level, I could just do it electronically. So I wasn't thinking about the paperwork, but I'm just happy that I have a printer that had the capacity to do it. But of course, the paper it felt like I was touching a hot iron by the time it was finished that night. Because I waited to the last minute, which I should never have done. But because I just had to go back and look at the rule, I didn't have the right to file to serve everybody electronically. And that's, and by the way, I'm glad you mentioned the notices. You look for the notices, but it's your responsibility, people.
Yeah.
It's not their case. It's your case. So these burdens and these assumptions and these other things that you're thinking, read the rule, find out your issue, find out what the rule is, read the rules, and then proceed accordingly. It'll save you a lot of heartache and grief, because you don't want to miss deadlines. Because when you're a self-represented litigant, particularly if you become a quality self-represented litigant, and I'm not boasting, but I face a lot of challenges as a self-represented litigant because I've developed a reputation, rightfully or wrongly. I don't go in courtrooms yelling, and I don't shut down courtrooms. And I don't, do I bring pressure? That's a different issue. I just try to stick to the rules. And by the way, they can always go watch me in court too, Maestro, right? So I'm not as gregarious in courts as I am in a hearing. But it's although they're both sometimes going to be viewed by judges, that's not the place to do that. I'm here to get something accomplished. So, but I've learned through this, you better make sure you have your ducks in a row, I's dotted and T's crossed, and know what to expect. And if you know you have a case, if it were me, if you have 10, if you find out the rules, how many days you typically have to respond, how many days after an order you have to do something. And if it were me, I'd check every 3 to 5 days, because that gives you that appropriate window, and it does depend upon your state. So, and keep in mind,
that's the key. It depends upon your state. It also depends on what kind of case, whether you're civil versus family court versus criminal versus insurance. There are a lot of variables, to your point, that go into it. So that when you had said in terms of the e-filing or being e-noticed, I've pressed the issue. Oh, trust me, I've pressed the issue multiple times. And this is why I'm going to be speaking at the committee, city council next month. So I'm going to be taking the page out your book, because I'm going to be letting them know, if you're not going to hear me in the courtroom, then you're going to hear me here at the committee, right? Y'all going to hear me publicly. And that's where the cameras are going to be on. That's where, I'm going to be saying the same thing, Greg, saying, hey, you can see me too in front of these people. Being clear, being coherent. But the reason why I said what I said was because of the fact that there was a motion I filed last year that was a psychological evaluation. And because they have to, especially because it's a juvenile court. Now, there's a difference too. That's why I said there's variables involved. Because in the appellate court, yes, I get e-notice and I can e-file. In the juvenile courts, and they've directly told me this over the phone multiple times. I pressed the issue. They're saying they are thinking about changing this and doing that. I've talked directly to the legal department. I've talked directly to the clerks. So they're not allowing it right now. And there is under the guise because, juvenile, children, kids, right? But in this situation,
well, I didn't mean to talk over you. Go ahead, and then I'll just come back to me.
But in this situation, the psychological evaluation that I sent out, they took their time in deciding on it, and I was moving at that time. So I filed for for an address change, right? So that way they would have where I moved to. Well, guess what? They sent it to the old address, and I thought they never ruled on it. So when I appealed, I made an error myself, not because I didn't know better, I didn't know what I was doing, well, because technically they did address my psychological evaluation that I filed. They denied it. I didn't know that they didn't address it at all because I moved and I never got the physical notice in the mail. And that cost me a lot.
Do you give them notice of your change of address? Put that in there for people to watch. Let them know when you change addresses. And the other part is there's only two types of cases. There's civil, and people say, well, there's administrative. Well, there's civil and there's criminal cases. Even administrative are typically, because they're going to be governed by the Administrative Procedures Act. Check your state, and the way that they can be dealt with, appealed, or what have you. But the difference is the rules. Civil rules may have different numbering, even though they're a similar style case. Family law seems to be within a, and I don't want to use the word jurisdiction improperly. They're kind of within a class of their own, because family law, even though it's a civil matter per se, there are different kinds of rules. In Florida, family law comes under 12, and civil comes under 1. So 1 point, like what I did to dismiss it, it's 1.540, which is motions to set aside, vacate judgments, and then there's 12.540 for vacating, and they kind of can intertwine to some degree. Mine was a procedural issue for actually both of them really, but the reality is understanding the rules. And I'm telling you, I learned a lot. I'll tell you, before you even spend money with me, see if you can find an attorney that you say, hey, can I pay you whatever their consultation fee is to let them help you with procedure. That I'd be lying. I'm not going to say their name, but the attorneys that have helped me learn through procedure and have slapped around some of my documents, without giving me advice or what have you, those consultations have been priceless. And I actually pass it on to you people. I'm not here to gatekeep, because I really don't want you calling me. I'm not kidding. But if you do, I want to make sure that I can tell you an answer, that I can give you a good answer, or at least direct you. And I've had very good tutelage, assistance, and guidance along the way. And the money's worth it. And that's even beyond the fact that I've taken a few law classes in school. Part of my background.
I can definitely say I had one instance where before I filed, I did talk with an attorney, and she really helped put me on game. She was actually the reason why I was able to understand to file multiple motions at one time. I thought you only could do one at a time. So when she told me to file, I filed my shared parenting, I filed a temporary time, and then I filed for last name change. Now they threw my last name change out because they said that they're supposed to go to probate court, whatever. But they actually took on. Yes, that was the reason for them denying my last name change of my daughter. I filed in the wrong court. But the shared parenting they took on, and the temporary order they took on. And I didn't have AI the same way that I have it now when I filed. And so to Greg's point, because I'm gonna show some love before I talk my shit. To Greg's point, yes, I definitely got some really good advice from an attorney. Now, this is the interesting part where I had used Legal Shield at that time. And so, it was just a quick consultation for about an hour. It was supposed to be for about an hour, ended up being like an hour and a half. And I guess she was just so interested in, my situation. She didn't even try to sell me either. She said, if you want to come back, you can come back, but this is the information that you need. And I appreciate that. Now, when it comes to fast forwarding, nah, When I hired attorneys, nah, I got further on my own than I did with them, but they definitely got paid. They definitely got the money out of me. But when it came to getting the relief I was seeking, I felt like I was being milked and I was the cow. And it was something that, at the tail end of my case, I ended up, hiring an attorney, and then I had to fire this attorney and I hired another attorney, back to back. And neither situations got me any further, but it did teach me something. And based on what they did, I was able to review how they filed. So that way I would have an understanding of what this court's expectation is. And I think that that's a huge thing too, to follow up on Greg's point. Talking to attorneys that deal with certain jurisdictions and certain courts will help give you more of the culture of the court, will help you see, the kind of structure, how they file. And that to me was priceless. Even though I paid a lot of money, tens of thousands of dollars for these attorneys, the priceless part was understanding the culture of the court, how to format my filings, and then, what kind of the expectation was. And I think that goes back to when we said before what the banner was up, in terms of why creating an error is cheap, but correcting is expensive. It don't really cost them much, for them to put something on a piece of paper or a docket, right? And that they assumed, presumed, whatever the case is. But you have to pay money in order to correct it, whether it's an attorney, whether it's the filing fee, unless you do, and I'm putting the next banner up right now, unless you file for indigency. And that's something that I had to learn too. And it was a catch 22.
Indigency.
Oh, indigent. I see. That's why I don't like saying these words, because it's just too much. All this Latin talk. Why are we still talking Latin? Not
I don't know,
plain.
being indigent Latin, I think this is a general term for being. I think the standard is the popular level. I didn't mean to laugh at you, but damn, bro. But okay, guys, like, what's he talking about? I was okay, indigent.
Being indigent.
The indigency form is the form they use to try to bring an action against me for perjury in an official proceeding when it didn't qualify.
Oh.
But had I not understood, it took me a while in the process. I'm like, I'm looking at 5 years for what? What did I do? But understanding that, but it all stemmed from an indigency application.
See,
so
catch 22. That's something I had to learn, that because I filed that because I really didn't have any money at the time. All my money was exhausted. Right, it just got exhausted. And I had to keep filing, and that's why we keep going back to the war of attrition. But here's the thing, and this is where, for my case, where I had to be careful with being in that, because once I hired a lawyer, obviously they had to remove me for that, right? You can't be on both. Like it just doesn't work that way. So once I hired a lawyer, they had to remove me on it. Now, technically on my record, it's still there. Yet every time I go to file, they ask me to pay that $20, because that's how much the fee costs here in Ohio, $20 for the filing. But on my record, it still has me as that. I've told them about that. I said on the record, hey, can you remove that? They have not removed that. And so just because you don't have, you've been given this opportunity basically to say, hey, you're indigent. Hopefully I said it right. Basically you broke, you ain't got no money. We still gonna let you file anyway. You still have to pay attention. There's still a cost to it. Is what I'm saying. Whether or not you're using AI, whether or not you're printing out documents, paper is not free, right? Ink ain't free. Doing things like that is not free. And I think it's very important to understand. Listen, no matter what you think, don't assume. This is why this assumptions could cost you. Don't assume that going that route is just going to get you out. Because they tried to backfire it on me by saying, oh, well, if you're in this position and you're indigent, then how do we know that you have the financial means or money to take care of your daughter? Like that. And that one, I'm like, okay, here we go again. Anything is used and can be, maybe, should, whatever the case is. It was all trying to be used against me no matter what. So I had to hit them back with the law and the rules and the best interest factors myself, saying, no, that makes no sense. That doesn't make any legal, lawful sense, because when I made the complaint about the mother living in a bad neighborhood, living in the hood, guess what they did? They didn't care. I said, wait.
You're careful not to say this is not legal advice yet, but they can't hold your economic status against you.
That's it. But guess what? They still try to. they still try to if they want to.
It's improper. That would be better for me.
It's improper.
And I see that the informer pauperis has popped up as well, so it's the same thing. Informer pauperis. Okay. And I came across informer pauperis more in federal court, because it's not about how much you make, it's whether or not you can carry the burden of the proceedings, because it can become quite costly.
Like that's what we talking about. Court,
because I don't know. I've done some. That was with. We were talking about what it would have cost me. Forget the filing portion, the presentation portion, the litigation portion of what I've done. The filing portion would have been astronomical too, because in fact, don't you just do it right now in front of everybody? Just pull up the cost of appeals for family law, average cost of a family law appeal, average cost of a federal court appeal. And I've done, I think we did, I don't know if we did on this show, one of my other ones, remember how many appeals I've actually done. I don't even know what that would have cost.
I can't even name it. I'm about to pull up chat.
I know I couldn't have afforded it, and it would have been even strenuous on my even on family.
Okay. So what was the question? The cost of
The cost of a family law, whatever appeal kind you want to appeal, you want to. I've done family law appeal. Well, yeah, I've done an appeal. I've done mandamuses. I've done prohibitions. I've done certiorari's at state, and I've done state. Oh, I actually now have a certiorari at the federal level too, don't I? So I did, because that's how I'm at the United States Supreme Court. So I don't know what the cost would be if I had to hire an attorney to do it. The filing fee is one thing. The cost of litigation is a whole different ball game, right?
it is a whole different ball game. I completely agree with that. Can you see it on the thing? What do we got here?
Yeah.
Okay, so I did Ohio and Florida since those are the two states that we're in. Yeah, for me it's $175, right? And then I have to pay another fee. No, I have to pay two fees actually. It's not even bringing up the other fee that I have to pay. For you 300. So yeah, they bring it up there.
Attorney hourly rate, 276 for as appellate. Look what it is
Yep.
in Florida.
It says about 353
An
an
hour.
hour. Yeah,
So you see moderately complicated appeal.
yeah. Appellate attorney rate 3 to 500
Look at complex and major appeal.
right here.
And then what? And shout out to Taisha Scott reporting. She stood in the paint and let me get her advertising that up there. But Scott reporting is, and I've also had Richard Lee reporting throughout my time doing this stuff. So any and everybody out there, if you get a chance, go ahead and holler at, get you a court reporter, get a good relationship with a court reporter, because you're going to need it. And I don't know how I could do that, but let's do it this way.
Yeah, because them transcripts get costly as well too.
But hey, kind of like going out in the woods.
Mm-hmm.
You don't expect to meet a bear, but it's better to have a gun and not need it than to need a gun and not have it.
Mm-hmm.
And so I'll stand by that wholeheartedly, and tell people I would not play with it if it were me. I'm not smart like the rest of you guys. I'm only a guy who's done it, so I'm not that smart. But I'll do this for the people who may otherwise.
So, but I would say based on just looking at the numbers that Florida is much more expensive.
All right, and here you go right here real quick. Give me 1 second. I think it's going to pop up there. Can you see the screen?
Yeah, let me bring it up.
There she goes. And I'm here. I got to do better with this. It'll be much better on my exit. But hey, you get it. If you need them, when it matters, she stood up in the paint. Scott reporting. Taisha Scott, owner and lead reporter since 2013. Hey, you can schedule on calendar at scott-reporting.com, and the transcripts at scott-reporting.com. Phone number 954-383-4955. Scott-reporting.com. Tell her Greg Dawes sent you. And I tell you, I like the American Express card. I wouldn't leave home without it.
I mean, that's some real good shouting out somebody that does that, because hey, I didn't have that. I had to go through the agency, I had to pay the money, and irregardless though, I don't regret it. It was not something that I wanted to pay out, but I was just grateful to understand that I should get the transcripts, right? Because it's one thing having, your own reporter. It's one thing having your own people, as I'm, your own supporter, right? It's a whole other thing when you don't even use what the court provides, even if it's costly. I'd rather have done something than nothing, because I know them transcripts gave my appellate brief, and gave my appeal a lot more weight, right? They were looking, it's easy for them to say, hearsay, she said, you're saying this and you're saying that. It's a whole nother thing when I'm saying, no, look at the right there. Look right there. What's so funny? I had an epiphany the other day. I know some people might disagree or agree. I don't give a damn. I really don't give a shit. But I believe 100% the way that I'm focusing myself when it comes to this potential third appeal that I might have to do. in terms of like the court record and them curing the record and things. I felt like Sophie Cunningham, right? And the reason why I'm saying that is because this is how I look at it. I'm just doing this to them. I'm just pointing that finger like this. Look at the record. I shouldn't have to say look at the record. The record states this. Now everything else is supporting, my position, but the record is the record. They can't just make that up, toss it out. And if they do, I don't believe that that's gonna, a lawful move, from my perspective. So it's one of those things where I had to look at it and say, hey, something is better than nothing. Yes, transcripts cost a good amount of money depending on the route that you go. But if you don't have that assumption, they're potentially going to make assumptions or presume things, and then you have to pay more money moving forward. Why? Because you have to fix it. I'd rather go into it the first place and actually get it done correctly than have to go backwards and fix mistakes. I hate fixing their mistakes. It's a revolving door.
And let me say this, without those transcripts, keep in mind the appeals courts have nothing to rely on other than the record. So if you don't have the transcripts, they have nothing to refer to helps to make a determination. So then by default, they're going to rely on the trial court's decision. Whenever, and I won't do it here, but you can go look it up. So we're not going to do that here. My appeals, and you've seen them, I cite the transcripts, and I attach them. And I tell you, there's no way that I have any success anywhere that required appellate review, and maybe even trial court review to some small degree, were it not for the fact that court reporter is there. Even when they hire court reporters to try to run off Miss Scott,
I can imagine that.
Because they'll use that to try to thank God for Calvin Dawes. I still get the transcripts. They'll actually hire a court reporter, not order the transcripts, because the copy is always less expensive than the original, and just have me get it to try to, and then I should speculatively try to price me out, because if you have the court reporter there, you should be ordering the transcripts. Why else would you have them there? Oh, you're trying to. We talked about shady tactics. They should go back and watch that video.
We did. That's a part of the shady I'm telling you, that's a part of the shady tactics. It's one of those scenarios where to me, I look at it as a video game. I really do. At this point in time, I just look at it as a video game. And because a lot of the things that they are doing is they're just trying to game me. It's like they're trying to put me in traps. I'm trying to put them in traps. That's literally what I've become. Like, I'm trying to set traps for them. They're trying to set traps for you. And the motion is set aside that I recently filed, that we got the win. I got the trial date set. Greg helped me narrow that down. And that was a trap. I'm gonna keep it all the way funky with you. I set a trap for these motherfuckers. I really did. And that trap was going to go two ways. If they did not give me what I want, you erred again. Now it's on the record. And not only that, this is your fifth or sixth contradiction on the record. But the thing is that I believe they didn't want the smoke. And here's the thing. And this is where you guys, as much as, you want to utilize a Greg or somebody like him, in terms of coaching and support, there's sometimes where you guys say, damn that. I got to do what I got to do. It don't matter if I have Greg or not, because Greg never saw my affidavit. He helped me narrow down the motion. He gave me a different perspective of why I probably don't want to make all these arguments in the motion, but I didn't share that affidavit with him. Why? Because I didn't want to hear him. I didn't want to hear his mouth. I just wanted to send that. I knew he was going to say something. I didn't want to hear it, and I sent it anyway. And the reason why I did was because the affidavit was my sworn testimony. I'm not arguing anything else, like legal arguments. I'm saying this is the record. This is my perspective. This is my interpretation. And this is what the facts are. And I had dates, times, numbers. I did everything, and I got it notarized. So that way it would be official. And I sent it in with my motion to set aside, because they won't take it if you don't have an affidavit that has been notarized. At least in my jurisdiction, they don't do that. So I made sure that, yes, I utilize, a person like a Greg for what I believe I need them for. But in terms of knowing that this is my fight, I'm in the fight. Even though Greg had a support system, there were times where I'm sure he had to get his butt up and nobody was there to help him, and he had to make a decision to do it or not. And that's just something I think.
my support system did not necessarily assist with the study part. It'd be no different if I was in college, my family is, they have they're credentialed academically for sure, just not in this area. And if I needed some engineering help, computer engineering help, or I got a pharmacist, I got OBGYN, and I have physical therapy, I got other things. This is just an area that it took me to get down and get I had to get down and get it in, and there was no way around it other than that. So but I had to do it. And the benefit that I have is I always knew how to be a student. I might have been a lazy one, but the foundation was set a long time ago. So, and I came up in an era where there was no technology. So I got my you explained it better than me. Like, I'm like the Flintstone guy who just kind of moved toward the Jetsons or whatever it is you said. But I just accepted what I couldn't do and could do. And I was willing to do what was necessary to become better or to become more efficient in that area. I know I can go in and change their system. So I had to learn how to operate, when in Rome. I had to learn how to operate within that system, and it benefited me. And it probably did help that I had some background in certain areas too.
I'm sure. Listen, you keep downplaying all this background. I'm shutting up, letting you speak. But I'm like, listen, everybody ain't got this immaculate background where, the Cosbys, the mama's this, and the dad's a doctor, and mama's a lawyer, and everybody is. Some of us, we just come from regular families, just regular schmegular, people. And I think it doesn't make an excuse on any side. If you're going to do this, you have to do this, and you have to understand it's going to take a while, unless, and that's why I say lucky. There's a lot of luck. I 100% say there's a lot of luck to do with this, because if they want, they can listen, I can't explain to y'all enough, man. The fact that my motion is set aside actually got them to give me a trial date, yet for months, they kept moving the goalposts, moving scheduling, not giving me any reason why. That scared me. That lets me know they can keep doing whatever they want to do until you get them in a position.
Keep in mind, they're going to be there anyway. That's their job.
And that's their job. Absolutely.
They're employed.
No, I agree. They get paid to do this. Yeah, that's why I'm saying listen, when I my civil case, yeah, I'm going for that gusto. I'm going for that gusto because you didn't wasted my money, you didn't wasted my time, you didn't wasted my daughter's life. You wasted time. You have one job. In juvenile court, you got one job: protect the child. Now everything else goes underneath that job. Best interest factors, everything else. You have one job, and if you don't do that job correctly, you need to answer for it. There's nothing else juvenile court is for except for children. Adults ain't going to juvenile court unless it's what they got, the Benjamin Button syndrome type shit. You got the opposite or whatever. As far as I know, that's not what juvenile court is for. So, I think that this is a scenario where the assumptions, man, a lot of their assumptions that they make, errors.
Say presumptions. One is it's presumed. When you're saying assumed, presumed.
Well, I'm correctly saying, I'm saying, because that's why I said at the beginning, there's two different words, assumptions, and I said presumptions. And I said, oftentimes we use them interchangeably. If I use it interchangeably in this situation, I'm doing it intentionally because they made a lot of assumptions. They did presume. They presumed to stay, but they assumed that mother's word was more credible than mine. We're both parents for the first time. Okay, when she made her accusations, they assumed her word was more credible without any evidence. That's assuming. Now, they presumed there was a stay when I tried to enforce the order that they
what made them deem the mother's words were more credible?
The guardian ad litem. Remember, we have that in our state. Unlike yours, that makes a huge. That's what I'm saying. Like, that's why I love you, Greg. But this is a situation like you tell people to know their own state. That makes a huge difference. That guardian ad litem makes all the difference. So because she got put on the case, if you're not used to,
we have them in Florida. But the threshold may be different because of our state's presumptions of equality and
50-50, right? Y'all 50-50.
That's actually new. That's more new, but yeah.
We ain't got no newness on the 50-50. And then going back to your point.
Hey. Not my fault you don't live in great.
I'm not, listen, but I'm taking a page out your book because when people say that, you can't, you can fight your own fight, but you also can affect legislation. Well, why would I say that? Because I'm going to the committee next week. We have a bill. It's called House Bill 550. It says it's about making compensatory parenting time, making it definite. Right now, it's not definite, meaning that they can decide not to give you any parenting time, even if you missed a year or two and the other person's found in contempt. It's not a definite amount of parenting time. So what I'm doing
As
is,
far as makeup, you mean as far as makeup time?
as far as makeup time, absolutely.
Wow, that's interesting.
Yeah,
See,
that's
I'm gonna throw this out here because I don't know what brought it about, but I have an idea what probably made Florida change a little bit, because despite what a lot of the narrative is, there's a whole lot of single mothers that don't look like us. Because at one time they used to always bring up the now, although the numbers in the African American community is higher for out of wedlock births, there are a whole lot of them in the other communities as well now, and that number is growing. And a lot of guys are getting slammed through support and what have you, and even in alimony. Now, it's interesting in Florida, if you look it up, Florida recently got rid of lifetime alimony, because you usually have rehabilitative and da. So now there's no more permanent alimony, unless you have to reach certain stages. So there's things that change, and I know they didn't change for us, okay, because we didn't necessarily fall into some of those categories. I'm just glad it got done, but for the guys who had those issues, that just wasn't my situation. But again, most of my procedural issues are in the past. So but procedural defects sometimes can be addressed forever, particularly if it's a procedural defect that goes to due process. Again, that's not legal advice, but take it for what it's worth. And that's kind of been helpful. So,
and the reason why I'm sharing this is because people like this is why you always let people know to know your own state, know your own case. Greg, you ain't got time to learn everything about everything. I know you don't. Listen, today? You ain't got what's the today?
And Greg doesn't care to. And Greg don't GAD.
Right. And so the reason why I bring this up to connect this with the aspect of, it's one thing fighting your case. It's another thing using your case and your story to help make changes, because they need that. They're not going to just make these changes. These people right here that are doing this, they need me. They need a story like mine. You know what I'm saying? So that way they can have reasoning and justification on why they want to move this bill forward. They need stories. Otherwise, what's the purpose of the bill? So that's why I'm saying it says to require compensatory parenting time. And I had to look it up. I said, wait, well, if they're trying to have a bill to require it, then it's not required. Then that must mean it ain't required. To me, that was a problem already in itself, in terms of how they're able to rule and the amount of power they have when it comes to the ruling. So that's why I said I'm taking the route of not only am I doing things as correctly as I possibly can, but I'm also going to step up and use my story and use the facts of the case, have everything coherent. So that way I get my 2 minutes and my 3 minutes at these committee hearings next week, and I can connect my story on why I believe this bill should get passed, or at least they should look more into it. I think it's things like that. I've seen you, Greg, many times in the committee, and I'm sure you've influenced somebody. I'm not saying that you've made a direct connection or correlation with why a law was changed, but until we do things like this.
Well, yeah, that goes without saying. I say the DOS effect. Yeah. I know there's been a DOS effect because it's been told to me. So, it's kind of interesting you brought that up. And somebody called me. In fact, they called. I think we were on the show, and I'm like, I don't want a fucking show. But they were saying that no, we weren't on the show. They called me. I was doing something else because they called me and say, it's become the talk around here. Your victory. I said, what victory did I have? And I say our victory. And they were saying, and it's circulating around the local child support office, and because they actually read the ruling. And I was like, well, if it doesn't matter what they think down there. What matters is what the people do as far as effecting. Because I'm one of the people that say I don't think you need to change the rules. You just need to make sure the people who are supposed to be the stewards adequately enforce them, and that's what was not happening. And so, you know,
That's that old school. That's that old school Steve Harvey. Old school. Listen, I want them to change the rules. I want them to change the laws. I want them to update some things because we ain't in caveman times no more. Things have changed. Equality is higher than it has ever been. You can argue the semantics about it, but you know, people have autonomy. People have jobs. People can make. They have freedom of speech. You know what I'm saying? Like, there's a lot of things that aren't what it used to be in the 1800s or the early 1900s. And so based on that, I 100% I advocate for to relook at the rules, to relook at these things. And it takes stories and people like a Greg, and I'm joining into that circuit, you know, to have them relook at these things based on the rulings. Like you just said, they look at the rulings, they look at your story, they look at a lot of stuff, and they make their decisions. We can't make them make their decisions, but we have to be there to in order to influence them.
We can't put legislation on cruise. We can't put democracy. I talked about it the last year. In fact, I got to do that. We can't put everything on cruise control, and that's what we've done in this country. Everything's been on cruise control, and that's on us as citizens of the United States. So,
I agree. And don't forget to like the video, y'all. For those of y'all who are watching, you know what I'm saying, please like the video, subscribe to our channels, because we are dropping game for y'all. Not legal advice, but just dropping game. You know, golden nuggets that you can take for yourself, that you can use what you need to use and learn your own state. Because as we just mentioned, nobody's going to know your case better than you. And
nobody should know it better than you.
Nobody should know it best. That's a better way of saying it. And what I've learned is nobody knows my case better than me. That's what I've learned. Not Greg, not the magistrates, not the judges, not the lawyer. Nobody knows my case more than me. Not even the AI. I argue with the AI all the time, and I love it. I love it because it helps me practice. It helps give me clarity on the assumptions that I might be making. Maybe I'm assuming. So I always say, hey, am I assuming something wrong here? What am I doing wrong? I'm thinking this, but it should be that. And the AI helps. Sorry about that, y'all. That my window's open. But the AI helps correct a lot of the mistakes that I would be making, or assuming that a case law is real. We went over that the other week about using AI for citing case law and how it hallucinates.
Yeah,
and those are assumptions as well. You're assuming by not checking that case law is real until you look it up. You know, it's costly. Those are
extremely costly. And one of the things that was told to me by is I tell people I treat all of the artificial intelligence like assistants, and Jarvis particularly. And when I was telling it, I said, you know, you kind of helped me become something different. You know what it told me? And it was like, wow, that's pretty interesting. It almost sounded like you. It said, Greg, you were handling 5 cases at one time across 5 different jurisdictions before I even came into the picture. All I do is help the drafting part because it can do it faster. But at the end of the day, you still review, you catch my errors, you correct my errors, you do the research. And that's where you were going to with people. It's like, yeah, I was doing this stuff when these things weren't there. Because again, people don't know my show's the one that taught me into using this stuff. You know, because I was hesitant because I was like, I don't know about that stuff. Because I'd already known about the disaster that Maestro did the show. We did the show on last week.
It does get disastrous.
I was always hesitant about using artificial intelligence. But, you know, I still do my own research from top to bottom. You know, there are going to be some errors. You know, the errors, they're going to be mine because I have to certify that I've checked everything. But yeah, I do quite a bit of research. But that was just a part of what I do anyway. But as far as the format or the outline, I still have to do all that stuff. And right. I still have to make sure I read line for line. And the reason why it's not such a deviation for me is because I make sure that it flows with the way that I speak. So the writing is the way I write. So it may not take me 5 hours or 6 hours to do a document. It may take me an hour and a half or so, but I still have to go through everything, look at it 1,000 times, make sure it makes sense.
Right.
And I happen to have the resource or research tools to do these things.
And even they mess up. Listen, I watched another case, and the judge was scrutinizing the lawyer. I rewatched that compilation AI video. The judge was scrutinizing the lawyer for using Westlaw. And I'm thinking like, well, that's supposed to be the AI for lawyers. Like that's supposed to be like the professional, and she said that it hallucinated case law. I thought that was very interesting. To
Did it
learn
hallucinate
that.
a case law, or did she use a case law that was not published?
No, the judge directly got on them because he said it hallucinated because they admitted they used Westlaw. They admitted that the lawyer admitted that, so that's why she got on them for that. At first they thought it was ChatGPT, but she corrected it and said it was Westlaw. So I think that's, and it could have been when Westlaw was earlier, right? It could have been the earlier version of Westlaw. I'm sure it's been updated a lot since then. I don't know.
Well,
But
it does give you disclaimers that what I've learned in my research through Westlaw is Westlaw will go and grab cases sometimes that have old holding dates.
Yeah, that too.
I typically stay away from old holding dates because I want to make sure that it's still good. And I always, it's not a secret. I look in Florida. If it's a Florida issue, Florida, the second DCA or the Supreme Court, and typically, even if it's a recent holding within the second DCA, if it's recent holding and there's something older, the recent holding will go back and cite the Supreme Court's holding if it's an older case. But these are just things you kind of just learn when you're doing this a lot, And I'm not being funny or flippant about it. It's just that's just the way that it kind of works. And it works that way because I have an idea of what I'm doing.
And that makes a big difference. So for y'all to wrap this up, because I know Greg has other appointments that he has to go with, so we weren't going to do a long show that we normally do.
Working in the background, huh?
But we definitely want to make sure that we're consistent, right, and that we are coming to you all with new topics. And there's going to be times where overlapping conversations happen because it's relative, right? And you have to keep sometimes being reminded. It's not just going to be a situation where you just learn it one time. I know that I've gotten a lot better at this. As Greg said last time, we talked about it, muscle memory. And that was a big thing that he had mentioned. And I have a newfound muscle memory because of this. And because I keep practicing with the AI or in talking with somebody like Greg, it creates more muscle memory. And the more that you keep doing that, you go over your case, you're able to say things like you just memorize a script in a book, or for a movie or something before you know it. Now, it doesn't happen overnight, but it can happen if you take your time. And so that was something I thought was important. And me and Greg had discussed it, a lot of assumptions, presumptions, and assumptions. And you got to look up that those are two different words, right? They have different meanings. And that's why I said we use them interchangeably, but oftentimes, but they are definitely different words if you're going to use it in the court system. And that's something that I know Greg likes to teach often. Be careful what you say, how you say it, and when you say it. And that's why I wanted to, clear the record that he was correct in terms of the word presumption, but I wanted to give a definitive example of the difference between the two. They literally said presumed stay on filings. They presumed that stay. But when it came to the accusations that came from mother in my custody, they assumed. They made assumptions that what she said was correct or what she was accusing had merit behind it. And it didn't. There was no evidence. There was no merit. There was no nothing.
And that's a good thing to talk about next time. What is an evidentiary hearing, how important it is to make sure that you get your evidentiary hearings in, because she made an allegation, and what's the rule for inclusion of evidence? Those things are important because she made the statement. I don't know if you had to object or what have you, how you had to raise an objection or how you argue against the court's taking the court's position and whether or not you preserved your objection on the record. Those are just different things that I've learned along the way that are important. Again, it's not for legal advice, just things that I've learned along the way. And if you go and listen to me in the court, you'll hear me say objection quite often, huh?
Yeah, that's important. Well, we can hit up that objections. I think next week. I know we have another topic, but we can merge that in there. I think that would be very important. So yeah, that's pretty much it. Thank you all for watching this video, whether you've attended live, whether you're watching the replay. I mean, that's what the whole purpose of the replay is for. So you can watch it whenever you feel like it. Huh?
Tell them how to find you.
Oh, yeah. I mean, of course. But I definitely wanted to, first shout outs, give them some love because somebody who's watching this needs that help. Somebody needs a little bit of that. But in terms of the channel, Premi Prego, you definitely, I definitely want you to subscribe to the channel. If my information that I'm sharing, my story, my perspective, my testimony is relevant to you. Outside of that, I'm going to put my email in the chat. But I have an agency, The Iconic Expressions. You can look me up, info@theiconic.expressions.com. I'm on LinkedIn as well too. If you want to find me there, just search for Maestro Stevens. I will be glad to connect with you on that front. And in terms of everything else, I don't really do much social media anymore. I just YouTube, LinkedIn. I got other things I got to do. But go ahead, Greg, and give your last piece. If there's anything else that you wanted to add to it.
Hey, listen, Tuesday and Wednesdays starting the 25th and 26th of this month. Not to mention on Monday nights, you can catch me on the Chop Shop Show. But starting Tuesday, I'll be on the Greg Doss DJ Squid podcast, the podcast for pro se litigants. And, I'll let everybody know that, listen, I'm an Army discharge service connected military veteran. And I've been standing in Florida courtrooms representing myself since about 2011. I'm not an attorney. I'm not your attorney. I don't have a license to practice law. I don't practice law. And nothing that I'm going to talk about on these podcasts is going to be legal advice. It's about my coaching and my education only. And I'm going to walk everybody through my personal pro se journey and discuss things. And it'll be a lot more clear, a lot more succinct. And eventually I'll start bringing on other guests and what have you, and talk about other aspects of the courtroom, to include bringing on my man Tondrick, who talks about the financial aspects of child support and other issues. I'll bring on an insurance person, Miss Bennell, who everybody seems to want to speak to. She'll talk about gaining insurance, what kind of insurance, the ins and outs of having good life insurance, what have you, and a couple of other people as well. Some people for veterans. Every fourth episode will be directed specifically at veterans and veterans' needs, whether it's veterans' mental health and other things. I'll be discussing that as well because, veterans are near and dear to my heart. Both my parents are retired service people. And I'll talk about education and other aspects, and I'll get into some politics as well and bring on some of our local politicians. And hopefully I'll be able to get a couple of people on who are running for office this November that you all can get on and say, hey, I think that if guys were to tell some of these politicians, hey, I need you, let's address the family law court. If you're willing to address family law, we're on your side. And everybody's talking about what somebody's going to do in family law, but everybody has these problems. So that clown didn't do it. Get you somebody else. And even at the local levels, get people in there who are going to push your agenda, and you have to become participatory. Because for those who don't know, the law is written by legislators. Mm-hmm. So for those who tell you voting doesn't matter, if it didn't matter this much, everyone be put into making sure that everybody does not vote. So that being said, if we're down, sometimes it's not about right or wrong. More importantly, it's about clarity. You'll never reach resolution if you're not willing to engage in honest dialogue, even if the dialogue is with yourself. Take time to hug the person you love and love the person you hug. On behalf of GD non-attorney, pro se consultant, and coaching, I'm Greg Doss. You'll be finding me more as the infamous DJ Squid on the Greg Doss DJ Squid podcast for pro se litigants. I'm saying peace. I'm saying chicken grease. Shout out to all veterans. Thank you for your time, Mr. Maestro. I'm out.
Peace, y'all. Thank you again. Oh, yeah, ladies. Lego to Prego. We out.